Castro of the Supreme Court, and Dean Cesar L. Villanueva of the Ateneo de Manila Law School, and Senior Founding Partner Villanueva, Gabionza, and De Santos Law Offices. May we request Dean Cesar Villanueva to proceed to the holding area while the interview on Associate Justice Teresita de Castro is being conducted. Thank you.
I do not know how to address again Justice De Castro. She was my PJ in the Sandigan Bayan. So anyway, would you mind? I'll just call you Justice Tess. Okay. So any manifestation, ma'am, before we start with the questioning?
May I be allowed to make a short opening statement?
As we did to the other candidates, we limited the opening statement to 3 minutes. Can you do it in 3 minutes?
I hope so.
Okay. Go ahead then, ma'am.
Good afternoon, Honorable Chairman and members of the Judicial and Bar Council. Should I have the good fortune of being appointed Chief Justice, I will bring to this lofty position my 39 continuous years of service in government, 19 years in the Office of the Chief State Counsel of the Department of Justice, and 20 years in the judiciary. I joined the government and rose from the ranks through devotion to duty, integrity, commitment to excellence, without reliance on any personal or political connections, but always with the assistance of the divine providence, the unseen hand which charted the course of my career in government. It is my long years of service in the government which helped shape my judicial philosophy and my reform agenda. My government service started when I was still under bar. I took the screening examination here in the Supreme Court, and I was hired as a law clerk with a salary of 500 pesos a month. That was in February of 1973. Later on, I served in the Office of Chief Justice Fred Ruiz Castro. So what are the lessons that I learned while I was in the Supreme Court during that early time in my career? I was already at the time as early on understood the importance of preserving judicial independence, and it was through my short encounter with Chief Justice Roberto Concepcion. The wholesome working environment in the Supreme Court at that time also fostered the spirit of professionalism and my adherence to integrity in public service. It was also during my stint in the office of Fred Ruiz Castro, the former Chief Justice, that I come to realize that docket congestion is the most serious problem of the judiciary. At that time, there were already 400,000 cases pending in court, from the lowest level up to the Supreme Court. And Chief Justice Fred Ruiz Castro was very much concerned of these clogged court dockets. So he proposed to President Marcos the creation of a presidential commission which studied alternative modes of dispute settlement, and that gave birth to the Katarungang Pambarangay Law, Presidential Decree 1508, which I helped draft during my service in the Supreme Court under Chief Justice Fred Ruiz Castro. The neighborhood conciliation system proved to be very effective. I know this for a fact because for a long period of time during my stay in the Department of Justice, I was a member of the Lupong Tagapamayapa. Later on, I was recruited by the Chief State Counsel whom I met in the Katarungang Pambarangay project to work in the Department of Justice. As I was first hired as State Counsel 1, then I became State Counsel 2, State Counsel 3, 4, 5, 6, then Assistant Division Chief, then Division Chief, and finally, Assistant Chief State Counsel. In the Department of Justice, I served 8 Secretaries of Justice, beginning from Vicente Abad Santos, Macaraig, and so forth, until the last one was Secretary Chofisto Gingona. And it was during the incumbency of 3 presidents, President Ferdinand Marcos, President Corazon Cojuangco Aquino, and President Fidel Ramos, who appointed me to the Sandigan Bayan. During the incumbency of President Marcos, I was a junior lawyer, so I worked in the background. But I had the golden opportunity of working directly with President Corazon Aquino and President Fidel B. Ramos, who awarded me a Presidential Medal of Merit for my exemplary service to the government during the peace negotiations. At the Department of Justice, I have worked on diverse and significant legal and constitutional issues confronting the political branches of the government during tranquil and normal times and during perilous and trying times in our national history, from the effectivity of the 1973 Constitution, the Freedom Constitution, or the Proclamation Number 3, which was promulgated by President Corazon Aquino during the existence of the revolutionary government and under the 1987 Constitution. What are the lessons that I learned at the Department of Justice? First, it is loyalty to the institutions of government, to the Constitution and the law. I have learned through my long service in the government that public officials come and go, but institutions remain. So we should all be loyal to the institutions of government, the Constitution that gives it life and substance, and to the laws that gives it form. Second, I also learned that it is important that there be stability and predictability in our legal system. The opinions of the Secretary of Justice, although persuasive in character, establish precedents or rules intended to guide future actions. So it is imperative that legal questions are consistently decided in accordance with law so that persons similarly situated can be guided in their action and expect the same ruling in the future. This is important for stability and predictability in our legal order. The third lesson that I learned is that the political branches of the government are equally concerned with the constitutionality of their actions. The Secretary of Justice as Attorney General renders opinion for all heads of government, departments, bureaus, and offices, the Office of the President, members of Congress, constitutional commissions. And in the course of this work, I came to realize that legislators, together with the President, are so much concerned with the constitutionality of their actions. And that is precisely why they ask the Secretary of Justice if their actions are within constitutional bounds. It is only when actual cases are elevated to the court that the power of judicial review is invoked and exercised. So in the first place, the political branches of the government, Congress, and the Office of the President would have the first crack of determining the applicability of the Constitution to whatever decisions they may take in the course of their exercise of their functions. They have all the vital information that they need in making policy decisions. The President especially has access to security and intelligence information, technical studies, empirical data, which are not available to the court. And therefore, it is for this reason that I believe that the judiciary should, in the exercise of its expanded power of judicial review, should exercise circumspection and utmost care.
How many more minutes, Justice Tess?
Just maybe 2 minutes, Your Honor.
Okay ba? Okay, sige.
So I
Go
also
ahead.
learned
With that promise of 2 minutes.
2 long minutes. I also understood the importance of technology. At first, we were using electric typewriters. Then we shifted to computers and word processors. It was a difficult adjustment, but it turned out to be very good in the long run. So I believe that we should emphasize also the introduction of technology in government service. I had greater exposure to this when I was promoted to the Sandigan Bayan and later on to the Supreme Court. So at the Sandigan Bayan, what did I learn? You know, I was not from the judiciary. I came from the Department of Justice. But my work in the Department of Justice helped a lot in the discharge of my functions in the Sandigan Bayan. And that is where I learned that experience really is the best teacher. So when I took over the Coco Levy case, in 6 months, I was able to decide that case the decision of that case has long been delayed. It has been in court for 16 years already. Now, because of my exposure to legal issues, legal problems in the Department of Justice, it took me a very short period of time to dispose of that case. I also was able to harness the legal knowledge that I gained in the Department of Justice and was able to use it for the benefit of all judges and all members, together with the justices in the judiciary. The step increments, which is allowed by law since 1982, was not applied to the judiciary. It was already 1997 when I joined the judiciary, and that was the only time that I initiated the process of applying this step increment to all members of the judiciary, and true enough, it was approved by the Supreme Court, and because of that, all judges and justices now enjoy the step increment, which allowed them to have a salary of the next salary grade without being promoted, simply by their long service in the judiciary. Now, I also learned that the judiciary is not for the weak of heart. It's not for the timid, and for one who is afraid to take not only a great responsibility, but a responsibility which may cause a tremendous personal consequence, not only to oneself, but also to one's family. I went through this in the course of my work in the Department of Justice. So I was given the fortitude and the courage, without any fear of consequence, to deal with cases involving powerful and influential persons. I have understood since then that public office is to be wielded for the common good and not for personal gratification. I learned too that keen understanding of the government bureaucracy is important. Having risen from the ranks, I understood the plight of government employees and their sensibilities, even those in the lowest echelon of government. So as presiding justice, I avoided any appearance of extravagance. I was very judicious in the expenditure of public funds. And in my 4 years as presiding justice, I did not purchase an official vehicle for myself. I just used the vehicle that I inherited from my predecessor. And that was until I was promoted to the Supreme Court. I saw to it that promotions and allocations of court resources were based on objective and uniform criteria. I treated my colleagues with courtesy and respect so that I can motivate them to cooperate with me in the judicial reform programs that are being undertaken at that time in coordination with the Supreme Court. And this earned me the Supreme Court Judicial Reform Award from Chief Justice Hilario Davide. I also knew that it is important to be able to reach out to other government institutions and agencies, because it is only in this way that you can expand your vision and perspective and be able to avail of the resources that can improve work efficiency. In the Supreme Court, I'd like to inform the JBC that I am now the working chair of the First Division. I have been elected by my peers as vice working chair of the Committee on Ethics and Ethical Standards, and I chair 3 more committees: the Management Committee of the Judicial Reform Project, the JRSP Working Committee, Component A, Improving Case Adjudication and Access to Justice. I'm chair of the Committee on Computerization and Library. I am co-chair of the Halls of Justice Coordinating Committee. I'm chair of the Committee on Gender Responsiveness in the Judiciary. I'm chair of the Special Committee to draft the rules on sexual harassment. I am member of the Committee of Internal Rules of the Supreme Court and of the Committee on Publication of Court Systems Journal and the Supreme Court Committee on Public Information. The Management Committee of the JRSP coordinates the implementation of all the components of the Judicial Reform Project. And I am committed to pursue these components of the reform project, which are improving case adjudication and access to justice, enhancing institutional integrity, strengthening the institutional capacity of the judiciary, and the stakeholder support for reform and program management office. That would include the IBP, civil society, and the community. Apart from all this, I am now the president of the Philippine Women Judges Association since 2009. And within this period of time that I have assumed the presidency of the PWJA, I have brought the PWJA to international prominence, which led to my being chosen as the president-elect of the International Association of Women Judges, a world organization with about 108, with members from about 108 countries. So, Honorable Chairman and members of the Judicial and Bar Council, I would be ready for work from day one if I am nominated and appointed Chief Justice of the Supreme Court.
Is that all, Justice Tess?
Yes.
Yeah, it was indeed a long 2 minutes. Yeah. Okay. Now, Attorney Cayusa, please.
Thank you, Mr. Chairman. Good afternoon, Justice De Castro.
Good afternoon.
Actually, most of the questions that I had prepared have already been answered with your presentation, but I just have a few more. As the Supreme Court Committee Chair on Gender Responsiveness in the Judiciary, I know that you have had several seminars on gender sensitivity and responsiveness, but have you had a chance to monitor how effective these seminars and this orientation have been in promoting gender sensitivity?
We have a committee which is in charge of that. And I think right now they are trying to come up with the criteria to be able to determine that. But as of now, we try to see to it that the Supreme Court is gender sensitive. For instance, we look at the number of employees and see what is the ratio between women and men. And we also see that if we want to find out if our employees are following the rules that we have uh, put in place to see to it that in the court, the employees and officials are gender sensitive, like in the use of their language. We have come up with a gender sensitive language book, manual, and we want to find out if they're following this. Even the court has come up with rules as to how we will address women and children who are victims of crimes.
Thank you, Justice, because I know that it's very active in the Supreme Court, but perhaps there is need to monitor how the effects, if any, on the lower courts. Moving on, you are the president of the Philippine Women Judges Association, and there are more and more women entering the judiciary. Proof of that is that more than half of those whom we interview are actually women. What programs or what do you think can be done in order to effectively harness the resources that you have among women judges in order to promote the administration of justice?
Before I answer your question, I would like to, the PWJA would like to thank the JBC and the President for the numerous appointments and promotions that our women judges had so far been given. In fact, we find it difficult now to look for replacement because every time there's a movement, we have to replace the directors and the officers. And that was because of the numerous appointments and promotions of our women judges. Going to your question, you're asking about what we can do to...
What projects have you done in the PWJA to harness this? Well, it's good that actually we do consider a lot of women judges for promotion and all. I mean, of course, based on merit, not just on gender. But I would like to know if you have other ways of harnessing, their capabilities towards helping in the administration of justice.
Yes, in fact, we hold regular meetings, and during our meetings, we discuss how we can help improve the administration of justice. We not only in terms of the performance of judicial work, but in the declogging of prisons, the decongestion of prisons, extending assistance to prisoners in order to alleviate their plight. We have also professional development projects for the judges. In the PWJA, we see to it that our women judges are able to avail of available opportunities to improve their skills and their knowledge. And we were able to send some of our women judges abroad to study on a scholarship and also to attend domestic seminars for professional development.
Thank you, Justice. Now, on another note, well, actually, you outlined several proposals in your opening statement as you gave a summary also of your career. Among the proposals that you stated in your opening statement, which, well, although you were not able to complete the presentation, we were given copies prior to your interview. Which would you consider a priority?
Improving the case adjudication. As you know, as I have mentioned earlier, this was the congestion in the court's docket was a problem in the 70s when I was still a young lawyer. And now it's already the 21st century, and still we have this problem. And the cases from 400,000 in the 70s has gone up to 700,000 now. And so I think that while we have been implementing reforms, I believe that we need to do more. And there are a lot of measures that we can undertake to be able to improve the adjudication of cases and make sure that we can speedily dispense justice. It is there are several ways. One, we can look at the rules of procedure and see how we can reform our court procedure to be able to speed up the disposition of cases. Our problem when I was in the Sandigan Bayan, one major cause of delay was Rule 65. So we had workshops on how we can limit the number of cases being elevated to the court with the use of Rule 65. We have also introduced a lot of measures here to improve the rules of court. We have speedy ways of dealing with the small claims cases, not only through improvement of the rules, but also through computerization. We can also make use of the alternative dispute resolution mechanism. Mediation, as you very well know, is still at its early stage, and there is a lot more room for improvement in terms of the professional development of the mediators. They are given trainings, but I think they are not really that in-depth. They need to have, I think, more extensive training, and there will be a lot of these available, not only here in the Philippines, but abroad. And there's also a problem about improving their salaries or giving them more salaries. And aside from that, the problem with mediation is that there is no regular budget for it. So we're relying on the fees. And we need more resources for the PhilJA to be able to concentrate on mediation. I am a keen advocate of this alternative dispute settlement mechanism because I myself experience how this can declog the court docket and how mediators can not only settle disputes but ensure peace in our society. And the Katarungan Pambarangay, although we cannot do anything to expand the jurisdiction of the Katarungan Pambarangay because that will require a legislation to amend the Katarungan Pambarangay, but perhaps the judiciary can support that. We are still relying on the penalties provided in the in our penal code, which was taken from the Spanish penal code. And so if we go by the penalty provided for crimes under the revised penal code, there will be a lot of cases really excluded from the Katarungan Pambarangay law. So I think that we should give priority to that because the lack of public trust and confidence is brought about by the delay in the disposition of cases. The more cases we have before our courts, the longer it takes for them to decide the case. We were told that the way we are treating cases in court is like distributing delay. Because, the courts would schedule 10 or 12 cases in a day and then let this case be heard for 30 minutes or 1 hour so that everyone will have time to be heard. But litigants expend a lot of money to go to court only to be heard for 30 minutes or for 1 hour, and then the case is reset for after 3 months or 4 months. So our system is really contributing delay among all the parties litigants. So when I was a presiding justice in the Sandigan Bayan, we were experimenting on continuous trial. It is difficult to just impose it right away, but it has to be done gradually. So what we did when I was there was to select simple cases. cases where the crime involved is not so difficult to deal with, when cases where there is only one party involved or one accused involved, because there are cases there where there are 25 accused, and these 25 accused would have 25 lawyers. It's so hard to hold continuous trial in that case. So we were starting with simple cases, and I think we should try to experiment on that. I didn't know what happened when I left the Sandigan Bayan. I no longer was able to see what happened if they continued with the experimentation. So there are so many ways of improving access to justice, making it more speedy, making it more efficient, and we just need to have this political will to be able to do it.
Thank you, ma'am, especially on your emphasis on court annex mediation. As earlier told by Justice Carpio, our success rate is 78%, which is quite high. So that's an average of 7 out of 10 cases referred to for mediation are actually settled. And that really dramatically reduces the court docket. Plus the fact, and perhaps many do not know this, that you don't have to be a lawyer to be a mediator in court annex mediation. And no matter what the amount involved is in the case, a mediator gets the same fee. Okay, so it's something like 700 or 800 pesos. So it's really, actually, it's also public service. It's a form of public service to be mediator, and I think it's necessary for them to get the right support through training, so that we can ensure the continuity of the program. I just have 2 more points, ma'am, if I may. In your long career in public service, do you recall of any instance where your independence was put to test when you had to make a decision against the wishes of the appointing power?
I'd like to say that I have been very lucky in the course of my career, whether it was in the Department of Justice or here in the judiciary. I have never experienced any pressure at all. I was allowed to do what I believe was right. Because if you have established that reputation, that you know what you are doing, and that you have integrity, I don't think anybody would ever try to influence or pressure you. Because I would take that to be an affront to my dignity if anyone would ever do that to me. So, and fortunately, I have not experienced anything like that in the course of my long career in government, whether it was in the Department of Justice. I'm very happy to have very decent superiors in the Department of Justice during all the time that I was there. And even now in the judiciary.
Thank you, ma'am, for that answer. And for my final question, if appointed Chief Justice, a lady Chief Justice at that, how would you characterize a De Castro court?
I'd like to be remembered to be a court which is independent, where independent, efficient, where integrity is upheld, and where people have trust and confidence. And that we want to be remembered, I want the members of the court to be remembered as models of exemplary behavior and decency.
Thank you, ma'am. With that, I wish you luck. Thank you, Justice Leonardo De Castro. Mr. Chairman, I have no other question. Thank you.
Thank you. Attorney Mejia, please.
Thank you, Mr. Chairman. Good afternoon po, Justice De Castro.
Good afternoon.
I understand, and based on our record po, you were previously nominated or you were previously interviewed as for the position of Chief Justice already. Were you shortlisted?
Yes, I was.
Um, kung halimbawa po na kayo ang napili noon, what would have been a De Castro court today?
I would hope that there was no impeachment, that I would not be subjected to impeachment, and that we're able to continue on with our work in peace.
Talking about the impeachment po, as you know, one of the major issues in the impeachment was the SALN, no? Kanina po, paglabas ko, may nagtanong from the media sa akin, Sir, why are Supreme Court justices hesitant to submit their SALN? Sabi ko, alam mo, ba't ako tinatanong mo? Hindi naman ako. Sabi ko, itatanong ko yan mamaya. So, itinatanong ko po, is there hesitance really on the part of associate justices or justices of the Supreme Court to submit their SALN? Kung meron man po, why?
No, I don't think there is hesitance. Because when we were appointed to the Supreme Court, there was already that old guideline. So we were just following the guideline. And that guideline was adopted because the court was worried about harassment being done to the justices by disgruntled parties. Now, if in the spirit of transparency, since that was regulation was adopted a long time ago, and many things have changed since then. There is greater demand now for transparency and for accountability. So I believe that we should give in to the popular demand and lay everything out. Anyway, we're not hiding anything from the public.
Thank you po. You mentioned earlier, no, in fact, in your opening statement, that you have formed the opinion that the court should exercise its expanded power of judicial review with utmost care. Can you please expound on that?
The power of judicial review exists within our system, constitutional system, where there is a separation of power, a system of checks and balances to ensure coordination, a harmonious coordination among the three branches of the government. And I have come to know in the course of my work in government that the legislators and the president oftentimes are required to make policy decisions. And their policy decisions are based on many factors. The members of Congress have to know the pulse and the sentiments of their constituency, the people who elected them in office. So do the president. He has a constituency it's a bigger audience to address when he takes official action. And aside from that, they have technical information which are not within the reach of the court. The president is concerned about national security. He would have classified information on military matters, technical studies on matters affecting the economy. And he is confronted with the problem of our overseas contract workers. Not only because they are sending us dollars and helping the country through their remittances, but also these thousands and millions of overseas contract workers have families here in the Philippines. So the president has to take care of them. We have our foreign relations. Other countries may restrict trade, the export of Philippine products if we take a particular action that is not to their liking. We we are attracting foreign investment. There are so many things that the president would have to attend to. So the court should understand that we do not have all of this information, and so we should be very careful in declaring unconstitutional the acts of the officials in the political branches of the government.
How would you maximize po in your court the role of the court administrator?
I think the court administrator must be proactive. He should be able to reach out. You know, in the course of the implementation of the judicial reform project of the court, I had the chance to go around to meet with our judges. And I know that face-to-face discussions between ranking officials of the court and the judges on the ground will contribute a lot to solve problems and to speed up the disposition of cases. Like for instance, in Lapu-Lapu, it took only two meetings with the judges there, and there was a marked improvement in the disposition of cases. I had to go to Lapu-Lapu because that is a model court. And so I think the court administrator must be accessible to the judges, spend enough time hearing them, listening to them, and discussing with them the problems of the court.
Ng pagkakataon yung ibang naimungkahi na katanungan para itanong sa inyo, no? Yung iba po comment at suggestion. Ito siguro, kung magbobotohan siguro at hindi appointment, palagay ko baka manalo kayo by popularity. Kasi po, sabi niya, maari bang i-consider ninyo na yung mga bumabagsak sa bar, yun na lang binagsak nilang subject sa bar, yun na lang ang kanilang i-take? Ano po ang opinion niyo tungkol doon?
Hindi naman masamang pag-isipan yan. Lalo na kung matataas ang grade sa ibang subjects. You know, every time that we are deliberating on the passing mark in the bar exam, I always take into account those who are to be disqualified. Kasi I have known a case where this examinee could have topped the bar, but he was disqualified in one case. So there may really be cases where it is not just to make them go through the entire examination, but this will require a lot of study, and perhaps we need to evaluate. I don't know if we're capable of evaluating the examinees individually, because it's so hard in a situation like that to generalize. So perhaps we could first take some statistics to see how many failed just in one subject but got very high in other subjects, for us to reconsider this policy of the court.
Thank you po. Ito ho, natugunan na nasagot na po ni Justice Abad kahapon, pero paulit-ulit po yung tanong. Siguro, baka hindi nakikinig kahapon itong nagtanong nito. At hindi lang po isang nagtanong. Baka po maikling short comment po again dun sa trial by jury. Mukhang sabi ko nga marami ang nabibighani sa panonood ng law and order. So can you please again give us your take on the matter of adopting trial by jury? Briefly lang po.
I'm not in favor of adopting trial by jury. You know, in the US, that has a very, very long history. It's part of their culture. Hindi yun parte ng kultura natin eh. And I don't know if the citizens will be willing to devote time to the trial of cases. And sometimes there is also that problem. In the US, they have a problem with that. They need to orient the jury members, they need to be told what are the issues, what they should look for, so that will put additional strain on the operation of our justice system. In the U.S., they allow this in both in criminal and civil cases, but to a lesser extent in the case of in civil cases. But I know they are encountering a lot of problems because they are paid. That's additional expense, but the pay is not also enough for them to leave their family or to leave their work. And there is also a problem. I think in the U.S. Before, they want to make sure that the jury members do not read the news, do not watch the television, or do not know anything about the case. But how can you do that now with the internet and all these gadgets? You cannot anymore sanitize the jury members. You cannot seclude them from what's happening in the society. And I think the important thing in the jury system is that the members of the jury do not know anything about the case, have not encountered anything in connection with the case, so that they can be objective. They are finders of fact in the jury system. The jury finds the fact for the judge, and the judge would apply the law. But there are also occasions where the judge do not agree with the jury, so you add more conflict in the criminal justice system, and there is disagreement between the judge and the jury.
So yun po, sana nalinawan yung mga nagtatanong kasi ang dami pong nagtatanong tungkol sa jury system. May final question po. Paano ninyo maitataguyod ang women empowerment sa Supreme Court?
Sana marami pang ma-appoint na lady justices, lady judges. Kasi I say this because if you consider the ratio, there's still a big gap, no? We have only 609 lady judges and justices from the highest court down, and this comprise about 33% of the entire membership of the judiciary. So I think in that area there can still be room for improvement. And I know I don't have any gender bias against the men, but I'm just saying that from my experience, I feel very much fulfilled working with the lady judges. I would not have been elected president in the International Association of Women Judges if it were not for the cooperation that I got from the officers, directors, and members of the PWJA. Many of them are very diligent, very capable and competent, very dedicated to their work. And I think the Supreme Court can utilize their this spirit of cooperation of women judges to be in the implementation of our judicial reform projects in the Supreme Court.
Thank you, Mr. Chairman. Good luck po, Justice De Castro.
Justice Lagman, please.
Thank you very much, Mr. Chair. Justice De Castro, good afternoon. During the impeachment trial of the former Chief Justice, the moral fitness of a Chief Justice came out. In your perception, what is moral fitness, which should be one of the criteria in nominating and appointing a Chief Justice?
I understand moral fitness to mean not simply obeying the law.
Yes.
Because you should transcend that. You must see to it that your actions are in accordance with proper, decent, and that you do not go beyond the bounds of ethics. So it's not enough to say that I'm obeying the law, I'm following the law. But we should be very careful in seeing to it that we observe decency, propriety, and ethics in all our actions. And not only in our official actions, but also in our private life. We should be models in our community, models of moral fitness.
Okay. You have stated that you are the vice chair of the Ethics and Ethical Standards Committee in the court, so I'll ask you this question. It is of common knowledge that the judiciary now is burdened by an image of corruption allegedly committed by most of its members. Now, former Chief Justices have tried to address this problem, but apparently they failed because this problem still persists up to today. If you will be appointed as the next Chief Justice, how are you going to root out the corrupt in the judiciary?
I think it is important for us to have a feedback mechanism.
How are you going to do that?
Yes. We should enlist the support of the integrated bar and the community in this feedback mechanism. I don't have yet the form of this feedback mechanism, but I think it's a way of putting members of the judiciary on their toes, knowing that
They are being watched.
they are being watched, and that we should have a standard criteria to evaluate judicial performance.
So, can you explain further what you mean by standard criteria? What is the standard criteria that you wish to implement?
Right now, the court is working on this, and it's really a difficult undertaking because sometimes there are judges who write very well, so it takes them more time to write their decisions, and these decisions are are usually affirmed by the higher court. There are those who produce a lot of decisions, but they are all reversed. So there are many factors to take in consideration, and we have a problem about finding who should evaluate them. They do not want to be evaluated by the executive judge because they feel they are just peers, and their work is not reviewed by the executive judge. So we should really look into this, have a scholarly and well-studied measure to evaluate the performance of our judges.
Are you telling us that your basis for evaluating the performance of the judges will be their decision, the percentage of affirmance or reversal of their decisions?
No, not only that. That's why I said we should study the criteria that we should use in evaluating judicial performance, and it cannot be as simple as that. There are many things that we should consider.
Okay. Now, Justice De Castro, what to you is accountability? And how are you going to promote accountability in the judiciary?
Accountability means being responsible for your action. It is not enough that you are not found out, because you all somehow, some way, you're going to pay for whatever wrong you have done. There's a higher being there watching over us, and so for me, accountability is not only something legal, but it is spiritual. It transcends what the law demands of us. And I think we should instill this sense of accountability through our Philippine Judicial Academy, the institution in the Supreme Court, which is taking charge of educating and developing the skills and the orientation of judges. And I think we should see to it also that legal education is reformed. I think we have paid very little attention to ethics. It's just a 1-unit course in college. So I think we should that should be allotted more units and given greater weight in the bar examinations.
Okay. Now, considering that the Legal Education Board is under the supervision of the Supreme Court and the Chief Justice in particular, how are you going to regulate the law schools in that regard through the Legal Education Board?
The Legal Education Board can decide on the curricula of the colleges of law, and I think this is a very potent way of looking at the administration of our law schools. I think the Legal Education Board has enough authority under the law to be able to reform our educational system, especially the law schools. And I think the Supreme Court should be more active. This Legal Education Board has only been recently organized.
Yes.
So
and it has not taken off.
I think the court should have a better or closer coordination with the Legal Education Board. Anyway, it is within its supervision and not just let it do its work without any supervision from the court. So I think that's one area which the court should also pay attention.
Okay, Justice De Castro, I have here some questions. In fact, there are many questions from our Twitter, which are all directed to you. And I want to ask you these questions. Okay, Justice De Castro, this is from a certain FCA. Justice De Castro, what can you say about the masses, rallies, banners, no work day in the Supreme Court during the impeachment to show support to a justice facing charges?
I didn't have a hand in the planning of these activities. What I just want to say is that anyone who tells me that there is a mass going on in the Supreme Court, I usually attend, whether it is for one purpose or for another. Whether it's for First Friday or for any occasion, I would go to Mass and attend the Mass. Now, aside from that, during the Mass, we pray for everyone.
Okay.
We
Not
pray
only for
for
a
the
particular person.
Not for a particular person,
okay.
but we pray for everyone. And I think prayer is very, very good.
Yes.
In fact, I ask so many people to pray for me now.
Okay. Okay.
So-
That's very good.
So
The power of prayers.
yes.
Now, another question from a certain Felipe Natanyo. How should the Supreme Court balance its response to people's demand for openness and transparency while guarding against tendency to become populist? How should the Supreme Court balance its response to people's demand for openness and transparency while guarding against tendency to become populist. From a certain Felipe Natanyo.
Is there? I do not perceive anything wrong with being populist, if it means that we need to be sensitive to the sentiments of the greater number of our population. I don't see any conflict between these two ideas. I'm both for transparency and also for seeing to it that we feel the pulse of the people without, of course, going beyond the bounds of the law.
Okay. Now, one last question, Justice De Castro. Just from Renza Riola. Justice De Castro, has there been a time when you totally opposed a certain decision of the Supreme Court?
Is it about writing a dissent or?
Yes. When you have
yes,
completely dissented.
Yes, yes, I do that if I really believe that I have taken the right position.
So in relation to that, another question is this. Has there been a time when you regretted the action which you have taken in a case which you have decided?
Fortunately, I have no regrets for any decision that I have done. I have never flopped or changed my position in the course of my work here.
So you have never flip-flopped?
No.
Okay. So on that note, Mr. Chair, I have no more questions for Justice De Castro. Thank you.
Thank you. Justice Hermosissima, sir.
Thank you, Mr. Chairman. Good afternoon, Justice.
Good afternoon, Justice.
Have you been, before you joined the government, have you been in the private practice of law?
I had some experience in handling family cases. So it's not completely zero, but I would say that these are cases which were elevated up to the Supreme Court.
I was hoping that you may have joined us in the rough and tumble of private practice. That would be a good experience before you become a judge. Now, Justice Munoz Palma, Justice Amor Herrera had the ambition to become presiding justice as the Chief Justice of the Supreme Court. If you're appointed Chief Justice of the Supreme Court, you will be the First Lady Justice of the Supreme Court. Do you realize that?
It will be a great honor, but at the same time, it will put a lot of pressure on me to be able to prove that I'm worthy of the position.
So if you are appointed Chief Justice of the Supreme Court, what would be your judicial philosophy? Would it be different from your judicial philosophy as a mere Associate Justice of the Supreme Court?
I will be guided by the principles that the former Chief Justices of the Court have pursued all along, and that is dedication, dedication and adherence to judicial independence, a judiciary that is efficient, competent, that is able to earn the trust and confidence of our people, and which is humane and compassionate.
So what is your concept of justice?
Justice is giving everyone his due under the law.
Is it any different from the definition of social justice by Chief Justice Laurel?
It's different in a sense because social justice is limited in concept. It pertains only to the state being able to address the needs and the needs and the demands of the less privileged members of our society, and the needs of the greater number of our population, whereas justice in a broad sense may not have that social implication, but it may refer only to, say, a particular individual who is before the court.
You have any shorter definition of your judicial philosophy? You have made it quite long. You see, when you enter the portals of the Supreme Court of the United States, you will find emblazoned there the words equality under law. In the Supreme Court, what do we have? Batas, bayan. In your case, what do you have? Well, in the Integrated Bar of the Philippines has this to say: no master but law, no guide but conscience, no aim but justice. In short, what is your judicial philosophy?
A judiciary that is dedicated to the rule of law.
So, on what basis do we write our decisions? On the basis of law, of course. The law applied to the facts. So, if the law does not abide by your conscience, will you follow the law?
Yes, justice, definitely.
If the law does not agree with your concept of justice, will you follow the law?
Of course, justice, the law must be followed regardless of our personal opinion.
What will you do if the law is not in accord with your conscience, or if the law is not violates your concept of justice? What do you do?
Should still follow the law, because the law is the expression of the will of the majority of our people expressed through their representatives in Congress. And I cannot impose on the majority my own personal conception of what is just or what is unjust. And that is the cornerstone of an ordered society. We cannot go by our own personal biases and opinion, especially so if you are a judge. You have to obey the law, because otherwise there will be chaos and instability in our constitutional system.
Madam Justice, considering the unmitigated proliferation of deaths caused by violence of judges, journalists, and other private individuals, are you in favor of the revival of the death penalty law?
Personally, no. I'm not in favor of reviving the death penalty law or allowing its imposition.
So you do not believe that the death penalty law is a deterrent to the commission of such crimes as murder, parricide, rape, and kidnapping?
From what I see from the cases that go up to the court, it seems that it has not been a deterrent. The problem is the environment that these criminals find themselves in. Very often, it's not the law that is. It is not the law which will make them avoid crimes or heinous crimes. Sometimes they are forced by the environment where they live. And so I think I go for restorative justice.
Will you not change your mind if I tell you that quite recently the Federal Supreme Court of the United States upheld the constitutionality of the death penalty? This in spite of the opposition of American bishops to the imposition of the penalty of death. But 4 Catholics in the court voted in favor of the imposition of the penalty of death.
If it is provided for by law, I would do the same thing, Your Honor.
What the clamor now is whether you agree to revive the death penalty law.
That is not the only solution to the problem. I think there is a lot of reform that we should do in our society to be able to eliminate heinous crimes or lessen the commission of heinous crimes. But it will really take so much for the state to be able to do that, considering the state of our nation today. We have there are unemployed. There are people who are poor, but we cannot eliminate this. But I think we should focus our attention on alleviating the plight of the poor. Crimes are committed because sometimes there are a lot of rapes committed by fathers or uncles or brothers because they live in a very small place, and I think just imposing death penalty without improving the lives of the poor will not achieve the purpose of minimizing the commission of heinous crimes.
As a Chief Justice, or even as an Associate Justice, you should have your ears to the ground and watch out for matters which might come up to the Supreme Court for consideration and deliberation and judgment. Now, Congress is starting deliberations on the RH bill. Whatever you say here will not bind you if you become the Chief Justice. As Chief Justice of the Supreme Court, it is only proper that you have your ears to the ground, so to speak. The issue here in the foremost issue here in the RH bill is whether it violates the constitutional provision which holds that the state should protect the life of the unborn from the moment of conception. Now, question is, does life begin at the implantation of the fertilized ovum in the mother's womb? So what are your thoughts on this matter?
I think the crucial word there is conception. And that is I think it's very technical. I cannot give offhand the meaning of conception. So, when is their conception? Is it from the time of the union of the the egg and
the ovum?
And the ovum. And can we determine that? Can that be determined? Is there any medical way or scientific way of determining where the precise time when there is such a union of the sperm and the ovum? I think
this is only a test of the things that will come up before you when you become Chief Justice. That is just an example. So that needs a lot of study.
Yes, that needs a lot of study.
That,
because we cannot just go by the language of the Constitution.
On that note, thank you very much. Thank you for coming.
Thank you, Justice.
Secretary Mosgi, please.
Thank you, Mr. Chairman. Magandang hapon po, Justice De Castro, Your Honor. I believe the material you submitted is sufficiently comprehensive to allow me to form an opinion already. But I just want to be very clear about one other thing. I understand you are president of the Philippine Women Judges Association, and during the interviews, you evince a good bias on women. If I may be able to ask you then, do you think that corruption is gender sensitive? Do you think that men judges are more susceptible, more vulnerable to corruption rather than women?
I really cannot say that. I think it's more a personal thing. It's maybe it's in the genes or or in the environment where you grew up. Maybe the association that you had in the past or at present. So I don't think gender has anything to do with it.
Okay, Madam Justice, I wish you luck. I have no further questions, Mr. Chairman.
Ito ang mahirap sa panghuli eh. Wala na sana akong tatanungin, but I will just ask some questions. I hope my questions will not be too many. This morning, Justice Carpio was asked about problems in the judiciary, and he said, you agree with him that our number one problem is delay, and that we have to declug. And he came out with solutions that we have already implemented. We came out with the small claims, and with due respect to the lawyers, we do not anymore allow lawyers to represent clients. No, not because lawyers are the one causing delay, and that decisions are now made in small claims one day lang, di ba? Then he said that we also introduce judicial affidavits as form of direct testimony in special rules, no? He said. But I did not ask him this question, no, or my observation. Will you agree with me that the cause of delay is not only attributable to the court? There are other factors, is it not?
Yes.
I'll give you an example. I don't know if you agree with me. Ang tendency po kasi ng Pilipino mahilig mag-file ng kaso Hindi ho ba? Oh, tingnan mo. Highly publicized na insidente. Nag-umpisa lang sa ejectment. Highly publicized siya na. Nag-issue ng BP22 Talbog cheque, yung ejectment nag-multiply ng 10 kaso dahil may BP22. Pagkatapos noon, yung may-ari ng apartment, pumunta doon, away sila, nag-file ng light coercion, grave threat, unjust vexation, ang dami na. Pagkatapos noon, yung nanguupa ng bahay, bumelta. Nag-file din ng grave threat, grave coercion, doon sa may-ari. Hindi ho ba? Hindi ba isang cause diyan ng delay? Kung ipapile mo lahat ng kaso yan nag-umpisa lang sa ejectment, nag-multiply, naging 15. Meron to ho ba tayong control doon? Sa husgado. Justice test. Magagaling ka pa sa observation ko.
You are right. In fact, the problem can be solved only with the cooperation of the integrated bar in the community. The integrated bar can help a lot in seeing to it that the lawyers follow the ethics of their profession, that they are made to realize that being a lawyer is a profession. It is the pursuit of a learned art where public service is important and earning a living is only incidental. But I think lawyers lose sight of that. If they even forget that they are officers of the court and that they should lessen their inclination to earn money, especially through
So ang suggestion mo,
encouraging court
so
litigation.
ang suggestion mo sana, Justice Test, yung those incidents, mga lawyers should have advised their clients, pag-settle na lang, ejectment lang Yung may-ari ng apartment, ayaw magbayad yung nakatira doon ayaw umalis magbabayad kuno ng BP22, nag-multiply na. Hindi ho ba? So another one is, what is your opinion, no? Because the maximum amount in small claim cases is 100,000. Beyond that, you go to the regular procedure, and this time, the parties will now be represented as counsel. Would you agree if we increase the maximum amount covered by small claims from 100,000 to 200,000 pesos?
You fully agree, considering the value of money now.
Paano yung mga lawyers nakasamahan mo nandito
Kailangan nga they should realize that being a lawyer is being part of a profession.
Isa pa, observation ko rin, I don't know if you will agree with me. We were both in Sandigan Bayan. Kasi sabi nila Sandigan Bayan, medyo mabagal ang maraming kaso. Hindi ba, sometimes also because yung laws mismo din, sometimes I'll give you an example, and I hope you will agree with me. Doon sa anti-graft law, sa Republic Act 3019, Section 3E. Yung isang empleyado hindi lang ni-promote. Magpapile ng case Ang ini-invoke 3E, causing undue injury through evident bad faith, gross negligence. Hindi ho ba? Nakakaabot sa atin yung kaso sa Sandigan Bayan Hindi ho ba?
Kasi very broad yung language
Very broad ng language Yung isa naman, gusto mag-travel abroad. Pinaboran ng mayor, ibang pinag-travel niya. Papile din. Ipapile din, 3E rin Hindi ho ba? Di ba meron hong ganun? Maraming ganun.
Yes.
Yung mag-retire na empleyado, hindi lang naibigay agad yung retirement pay niya. Papailan yung mayor. 3E na naman Hindi ho ba? Tama ho ba yun? Justice test. Tama ba yun?
These are minor cases which are decided by the
that's
Sandigan Bayan. There will be 3 justices
that's also
sitting.
So, anong remedyo natin doon? Legislation, hindi ho ba? Amendments isa pa. Kaya pinag-uusapan namin sa NBank Yung sa TEP at saka estapa, ang value 12,000 to 22,000 pesos. Ang penalty yun beyond probation yun 6 years and 1 day ang penalty nun 12 to 22,000. Nagnakaw lang ng nagnakaw lang ng 12, 15 or 18,000 I-convict mo yan, hindi na makapag-probation, hindi ho ba?
Kasi galing pa yan sa Kodiko Penal ng Espanyol.
Yung nga Ngayon, if you amend those provisions sa penalty sa TEP at sa estapa, if the amount is between 12 and 22,000, lower the penalty, probationable, sa tingin ko marami na magpo-probation sa TEP at sa estapa hindi ho ba?
Pati dun sa katarungang pambarangay. Kasi
yun.
if we go by the penalties provided for by the revised penal code, there will be many minor crimes which should be outside the jurisdiction of the Lupon.
So ang sa dakes ng husgado is not only the concern of the court, because we have been doing many things in the court in order to expedite the termination of cases. Hindi ho ba? Tama ho ba ako?
And
Justice?
yes, we need the cooperation of all the branches of the government. If I think many do not know that in the first level courts, dun sa municipal trial courts, there are no lawyers there except the judge. Imagine there are thousands of cases pending before the municipal trial court, and the judge normally judges do not have a lawyer to assist them. And I think it is very unfortunate that judges are overworked, understaffed, and unappreciated. We are being criticized left and right in public, but I think people should know that there are many dedicated public servants in the judiciary. Our judges are working under very dire conditions, and yet they stay on. There may be some who are doing not good things, but they do not comprise the majority. And I think we should be able to project to the public that the court is not as bad as they think it is. And I think our problem is that, especially us in the Supreme Court, we do not want to appear before the media to explain. I'm glad that yesterday Justice Brion had the opportunity to explain one of the cases.
You will have also the opportunity, because that's my next question. Because one of the concerns of the candidates in the first day of the interview, wala daw tayong work plan. But I told him that meron. But I could not follow up questions. Kasi he was surprised when I told him na meron tayong committees, may plans, I think you are the right person to answer, To answer if indeed we have plans. Now, you chair the Supreme Court Judicial Reform Support Program Management Committee. Can you explain to us what is this committee all about?
This is the committee in charge of coordinating all the reform projects of the Supreme Court. And the reform projects fall under 4 categories. There's component A. This is improving access to justice and improving case adjudication. 2, we have component B, which is improving institutional integrity. The third one is component C, which is improving institutional capacity. And the last one is encouraging multisectoral support. And that would include, as I mentioned, the IBP, the community, civil society. So this is a very comprehensive plan. This was well thought out. This was scholarly done since the time of Chief Justice Davide. But in the early part, we have been trying to study. We just cannot implement reforms without conducting studies. So studies were done, and you just do not give computers left and right. There is needs assessment. You just do not say that this office should be given 4 computers or 5 computers. You need a thorough study. There is a need to see to it that the financial measures and the budgeting of the judiciary is being done in accordance with well-studied criteria.
So the management committee, that's the main committee.
Yes, it's the mother committee.
You had mother committee, and you had 4 subcommittees.
Yes.
Now, you had the mother committee and the subcommittees. No, the subcommittees.
You chair one of them.
Yeah, you jumped the gun by different justices.
Yes, and I think what we have here is a unique arrangement. We were told that there's nowhere in the world where justices are actively involved in judicial reform. They usually focus only their attention to writing decisions. But here, the justices are taking active part in judicial reform. All the committees are headed by a justice and usually also assisted by 2 or 3 associate justices.
And do you actually meet on a regular basis?
Yes, you know when the Hall of Justice in Angeles City was being constructed, we meet every Monday.
So that's also part of the management program. That's included in the management program.
We have 2 pilot courts. One is in Lapu-Lapu and the other one is in Angeles City.
Which brings me to another question, because I see lawyers from Manila. Most of them are my friends. Ang tanong ikaw din pala in charge ng Halls of Justice, di ho ba? Sa committee mo. Ang tanong nila, saan ho yung Manila Hall of Justice?
Malapit na.
Can you tell us if funding has been already secured?
Yes, sa GSIS, the former GSIS property in Arroceros, and we already set aside more than enough money for that.
Oh, will it be?
I think 1 billion something.
I think it's 1.8 billion for the court in Manila Hall of Justice. Okay. Kaya ata nandito yung mga Manila lawyers yun natang gustong pakinggan
There are 108 salas in Manila that should be housed in that Hall of Justice, and I think we will add 10 more so that we will see to it that expansion in the future will be possible. Because there might be new salas created in Manila.
Yeah. And all these programs that you have been undertaking, and all these meetings, all the things that you have done. Ang tanong ko dun meron ba tayong sufficient funding? Kasi iba yung meeting ng meeting. Meron ba tayong sufficient funding to fund all these programs? Computerization, Hall of Justice, enhancement, lahat. Meron ba tayong funding dyan, Justice Tess?
Meron tayo. Yes, we have some funds allocated for that. But computerization is really very expensive. If we think of the entire nation or the entire judiciary, we need a lot more money to be able to do that. But for piloting, I think we can.
Yeah, there was another. I do not know if you can answer this question. I understand you are also the one in charge of the World Bank loan. Yes. What committee is that?
Part of the management. It's under the MANCOM. It's under the management committee.
It's also part of the JRSP. Yeah, it's part of the management committee, MANCOM.
The entire reform program consisting of these four components are funded by World Bank, but the term of the loan already ended last June.
Yeah, I ask you this because there were concerns, a lot of concerns. Everybody probably read items in newspaper that there was something wrong with the manner a part of the loan was spent. Can you tell us how much is that amount involved?
I think the amount of $115,000
No,
were treated as ineligible.
Yeah.
Not illegal or irregular, treated as ineligible.
That $115,000 is how much percentage of the whole loan?
That's a small percentage because the loan was about $21 million.
So $115 was considered
That was ineligible.
so in local auditing, if it is a government money, it is an amount that is disallowed.
No, it's not disallowed.
Oh, it's not even disallowed.
It's there is just a problem about where to charge this amount. Should it be should it be charged to the government counterpart fund or to the World Bank loan? You know, the World Bank sometimes would ask that expenses be agreed upon. Like for instance, just to give an example, well, this was not the ineligible expenditures. I had nothing to do with them. This was done at the project management level.
Yeah.
So we are not engaged in the disbursement of funds. None of the justices ever touch any money in that World Bank loan. We have nothing to do with it. Now,
What happened with that query?
Yes,
Because there was from the reports that the World Bank was trying to secure an explanation from the court through you. What happened with that?
There was a request that the matter be discussed, but according to them, we can point out errors in their aid memoir. So originally the amount I think was about $160,000 US. Then after some discussions, it went down to $115,000. Now this amount were spent on the, say, payment of an employee of the court who lectured about docket congestion. So the allowance given to that Supreme Court official was considered ineligible.
Mm-hmm.
So they're saying that should be paid by the GOP,
the counterpart fund.
Part fund. Now, someone was invited to go abroad to share information about our mobile courts, the IJAW, our mobile courts, and they said that it should not be charged to that. We had a visitor, the Chief Justice of Guam, who was treated to lunch in one of the restaurants here in Adriatico. They said that was not agreed upon with the bank, so that was that was considered ineligible. Those are minor expenditures, nothing spectacular about the disbursement of those funds. And I'd like to point out, ineligible does not mean irregular. It only means that it should not be charged to the loan, because according to them, you did not secure our agreement. So that means if somebody lectured or somebody went abroad, you have to secure the consent of the World Bank that it should be.
In other words, if there was no consent, that should not have been source from the loan from World Bank,
Yes,
from the
so-
counterpart loan.
So if you will look at the aid memoir, many of the objections there would be not agreed with the bank, not agreed with the bank. So the bank did not say it's irregular or it is unlawful. It's just that there should have been prior agreement with the bank, with the World Bank.
Aside from your work as a wise or working chairperson, you explain to us what do you mean by working chairperson
In the first
Justice Test?
division.
Yes.
Yes. As working chairperson, I perform the same functions as the division chair. Review all the reports being submitted by the members of my division. See to it that the agenda are prepared on time. See to it that the minutes are approved by the justices, and also that they are released. If there is any resolution that needs to be released in advance, I need to see to it that there is a good reason for that, so that is elevated to me for approval. Then I also review the ponencias of the other justices in the same way that
They review also your
review
ponencia.
also my ponencia. And unfortunately, the sharing, I do not get the same
Number
of cases in comparison with the other
Regular,
division, the regular division
Chairperson.
So I get the full number of cases allotted to a member of the division.
In other words, you are an acting chairperson because actually the chairperson of the first division is the
Is
Chief
the chief.
Justice.
Yes, the chief.
Because the Chief Justice has many things to do, instead of the Chief Justice presiding the first division, the fourth senior member of the court shall act as the chairperson,
Yes,
working
working
chairperson
chair.
of the
Yes.
first division,
Yes.
because the Chief Justice is the presiding officer of the en banc sessions.
Yes, and so because of that, since I perform the same work as as the other division chair, I should get. I should also, the number of cases assigned to me should also be reduced.
Yeah. I was
But
reading.
that has not been done for 2 years.
Dito may tanong dito eh. Kailan dapat pati ako tinanong din eh. Ito, itong tanong, I will read it's up to you if you want to answer this question. Pati sa akin marahil tinanong din eh. Do you think your appointment as Associate Justice a reward for the era of conviction? Galing sa Twitter ito, so I have to ask Justice Tess.
I don't think so. I've been in government for a long period of time, and I think I deserve my position. In fact, I think it was delayed. It was delayed because of the ERAP case. Because they wanted someone who has been there from the beginning.
Lastly, kasi I was reading your what you had done in the Sandigan Bayan, no? But I was trying to read something important to the Sandigan Bayan. Wala rito eh. Hindi ho ba ikaw ang responsible yung lupa sa Baguio City where a courtroom of the Sandigan Bayan is now constructed?
Yes,
Bakit hindi ho mo nilagay dito?
you know, I came to know about that land in Baguio because I was a member of the Committee on the Disposition of Idle Government Lands when I was in the Department of Justice. So I know that there are properties of the government which were lying idle, and because of that, I recommended to the presiding justice, was Justice Nazario then, that we can, maybe that is one opportunity for us to be able to secure a piece of land in Baguio. And we were fortunate enough to have 2 hectares in Baguio City. for the
Did we buy the lands? Did we buy?
no, it was given to us for free, gratuitously.
Okay, on that note, Justice Tess, I'm through. You are now excused, Justice Tess.
Thank you. Permission to leave.
Granted.
Your Honors, Dean Cesar L. Villanueva of the Ateneo de Manila Law School and Senior Founding Partner Villanueva, Gabionsa, and the Santos Law Offices is now ready to be interviewed.
You may not be seated. Dean, do you have a manifestation? No.
Yes, Your Honors, if I be allowed.
You want to deliver a appointing statement?
Yes, Your Honors.
As a rule, we allow limited only to 3 minutes.
Sure,
Unless you ask for a motion for a consideration later.
I will try.
But do not
that.
expect that it will be granted.
Yes, Your Honors.
Okay, go ahead then, Dean.
I'm not the Dean of the Ateneo Law School. I'm not also no longer a partner of the law firm. I'm actually completing by the end of next month my first year as chairman of the Governance Commission for GOCCs, which has been created under Republic Act 10149 as the central advisory, monitoring, and oversight body with authority to formulate, implement, and coordinate policies pertaining to government-owned and controlled corporations. I was appointed to the Commission in August of 2011 and formally assumed my role as a public official with the effectivity of my resignation from the Dean of the Ateneo Law School, having then served 7 years coming from 4 years of being the Associate Dean. I have been teaching law for the past 29 years, which coincides with the number of years that I have been practicing law, concentrating in corporate and commercial law practice. My acceptance of the GCG chairmanship also saw the end of my service as chairman of the Commercial Law Department of the Philippine Judicial Academy and a member of its academic council, positions which I've held since 2003. And the privilege of such service has given me the opportunity to contribute to the training of judges in areas of commercial law development, such as corporate rehabilitation and insolvency, intercorporate disputes, anti-money laundering, banking laws and practices, intellectual property, but more importantly, in sharing my philosophical outlook on our country's commercial law system. I also represented PhilJA in the Supreme Court in the MCLE Governing Board, which is chaired by Justice Carol Grino Aquino, and have been involved in upgrading the rules and proceedings by which accredited providers may better serve the training needs of Filipino lawyers. I continue to be a member of the PhilJA Corps of Professors. I have served 3 terms as members of the Technical Panel for Legal Education of the CHED, under the chairmanship of Justice Bernardo Pardo, and after that, Justice Jose Vito. I have been involved in the accreditation of newly opened law schools prior to the constitution of the Legal Education Board. I was also part of the committee that drafted the CHED memorandum that was formally adopted by the Legal Education Board, which has overhauled the standards of legal education in our country. During the incumbency of Chief Justice Renato Puno, I served as a member of the Supreme Court Subcommittee on Commercial Courts that submitted amendments to the interim rules of procedure for corporate rehabilitation. Until I resigned from the deanship, I was a member of the Board of Directors of the Philippine Association of Law Schools, PALS, serving also then as its vice president. I am a fellow of the Institute of Corporate Directors, a public foundation that seeks to promote and upgrade the corporate governance standards for both the private sector and within the government-owned and controlled corporation sector. I'm also a certified public accountant, having taken commerce or accountancy as my pre-law degree, even then with full intention that I will devote my legal career in commercial law development in our country. I've always been a keen student of Philippine commercial law, having published 5 books on related matters: Philippine Commercial Law Review, Philippine Corporate Law, Law on Sales, Non-Corporate Media of Doing Business, which covers the Philippine laws on agency, trust, partnership, and joint ventures, and recently the Law and Practice on Philippine Corporate Governance, which parenthetically won the 2009 National Book Board Award for Professional category. I have since my student days published various works on both constitutional and commercial law matters and delivered papers on the Philippine commercial system and the Philippine insolvency system before international fora. Both my private and academic work have been primarily geared towards the rule of law regime, particularly in evolving a commercial law system that treats of the operation of common law statutes within a predominantly civil law system. Your Honors, I am the product of the public school system, having taken up my elementary education at the Santo Rosario Elementary School in Angeles City, obtained my high school education under the tutelage of Belgian priests in the Chevalier School, and I obtained my college degree from the Holy Angel University, magna cum laude, and eventually became a member of its Board of Trustees. I am essentially, Your Honors, a provinciano, having left Pampanga only at 21 years of age to take up my law studies at the Ateneo, where I graduated valedictorian and cum laude. I continue to go home from my work each day to Pampanga. I am married to my college classmate, Arlene Sicanco, who is now the president of the Holy Angel University, and we have 3 children. Our eldest and only son and my other daughter are both lawyers. I am a lolo, with my first grandson being born to our youngest daughter 2 years ago. And we are expecting our second grandson to be born to our older daughter sometime in November of this year. By way of ending, I share my personal philosophy of the law. For me, Your Honors, the law constitutes the very essence of man's civilization. It represents the mind, the heart, and the soul of every society. Leading members of society set out a set of precepts, rules, and regulations which they consider important for the members thereof to live and grow in a civil fashion. That is law as the mind of society. For the individual members of that society, the law assures them of the power to determine the course of their lives, to seek fulfillment and happiness for themselves and their families, consistent with those of the desires and dreams of their neighbors. That is law at the heart of society. And finally, the law provides for them the means by which society can protect and nurture some of its weakest and most marginalized members as its primary expression of the collective duty to a higher being. That would be law as the soul of society. In all these 3 aspects, the law therefore epitomizes the ideals, the virtues, and the actions of a civilized society. Thank you, Your Honors.
Attorney Cayusa, please.
Thank you, Mr. Chairman. Before I propound my questions, I would just like to make it of record and disclose that Dean Cesar Villanueva was my professor in sales at the Ateneo Law School. Good afternoon, Dean.
Good afternoon, Your Honor.
You were recommended by, among others, the Philippine Trial Lawyers Association, and they come here in full force. What encouraged you to give your conformity and to be considered for the position of Chief Justice?
Well, first and foremost, I think our nation in general, as well as our judiciary in particular, are at a crossroads. The vacancy has been created through an impeachment process that have fitted many of our great institutions. And therefore, men and women of goodwill in this country ought to show that they believe in the process, in the selection process. And therefore, when I was nominated by the Trial Association, I thought it was an honor for them. It was an honor for me to honor such nomination and participate in the process, to show that it is possible to continue, for democracy to continue to march on, especially in one of the most important branches of judiciary, of the government, which is the judiciary.
You have been in your current position for, as you mentioned, just almost a year. Now, what made you decide that this would be the proper time to maybe change course, because you have always been involved in commercial law, and in the judiciary it will be a completely different orientation? Why this at this point in your life?
Oh, basically because I believe that the Supreme Court, as it fashions out and explains the precepts by which our society moves on, and on the constitutional mandates, economic mandates, I think that being part of the Supreme Court and molding the decisions by which to look at and update the commercial law principles of our country as they are connected with constitutional precepts is an important task. And I had even my works, Your Honors, have always consisted of looking at how the Supreme Court, through what I call judicial activism, has been able to move on to international standards, the commercial law standards of these countries, to allow us to compete well with the rest of the world. So the Supreme Court, through its precedent-setting powers, is at the cornerstone of that great process, Your Honor.
Notwithstanding the fact that you have only been in government for less than a year, what have you set out for in the judiciary, particularly with respect to judicial reform? What do you propose would be the bedrock of a Villanueva Court?
A Villanueva Court is one that looks at the end of that term, if it comes to pass, you would see a Supreme Court that has allowed itself to be shown to the public as a great institution that has worked cooperatively with the other two branches of the government towards fulfilling the wish of our people for a just and humane society. And a judiciary constituted of dynamic, competent, and well-motivated judges and their staff spread all over the nooks and corners of this republic in the various courts, that they become the face of the republic and the very epitome of judiciary, so that the common tao would see that indeed justice is accessible to them, it has a face, and it is demonstrated. And more importantly, a legal profession that is so motivated, considers itself every day of their existence to be truly quasi-public, if not public officers, but officers of the court, who will, in their daily task before the courts, in protecting their clients, are able to show that it is possible for our profession to be at the forefront of achieving a just and humane society. And that is all achieved by a Supreme Court that exudes the very foundation of what we call a just and human society through its procedures, through its decisions, and through the actuations of its very 15 justices, Your Honor.
Thank you, Dean. You have been part of molding the legal careers, I would say, of many of your students, this included. In fact, I would like to tell you that a great deal of style in instructing my students in law school, I derive the inspiration from your own style. But let me get to my next question with respect to legal education. You are still, I suppose, with the MCLE board?
No, I made sure that when I joined the when I accepted the chairmanship of GCG, I tried to make sure that I would be concentrated fully. So I gave up my other positions in government, even in those on a consultative basis.
So, but having served the MCLE board for many years, well, and also you mentioned that you have been in coordination with the Legal Education Board. There's one concern here with respect to the function of the pleb in connection with the MCLE. Is there any apparent conflict in the promotion of continuing legal education with the functions of the PLEB and the MCLE?
We do not see any conflict, Your Honors, simply because the LEB is actually in charge of legal education in this country for those who are still under bar, basically those who are taking up JD or LLB, but including now those who have already a license but want to upgrade their curricular norm by taking up an LLM. So it is the academic side of trying to mold the minds and hearts of what we call future lawyers. On the other hand, that would be LEB. On the other hand, MCLE has its focus on those who are already in the legal profession, ensuring that they continue as they strive towards fighting for the causes of the clients or protecting the lives and properties of the clients, that they continue to keep themselves abreast with the latest legal developments, so that the legal profession as a whole is one that is not only that is competent but has integrity in the manner by which it discharges them. So these are two institutions that look at the various stages in the legal development of those who would become or those who are already lawyers in our country, Your Honor.
With the current requirements under MCLE, do you feel that there is a need to change the required subjects so that it becomes more relevant to the legal profession?
Yes. That has always been asked of us, Your Honors, when I was still in the MCLE governing board. I think that what has happened is that after the first wave, when the providers started to put together this various MCLE program, that when the second term came about, they were still doing the same thing. I think it's important for MCLE to reach a point where there is a grading system, a graduation from basic to more modern providers. And I think that by requiring MCLE providers a program by which to allow those who have already taken their other courses to get better courses or graded courses, then it would be more relevant, Your Honors. The other thing, Your Honors, is that because MCLE is just graded and the amount of time that you spend in the lecture room, some of them actually just sleep through it. So the request of many lecturers is that we ask those at the back not to snore too loudly. And because there is no responsibility being imposed, Your Honor, I think that perhaps for them to take more seriously the fact that they have to learn something from the lecture, in spite of some of the lecturers, perhaps what we did in the Filja would make sense. That at the end of it all, they will have a short quiz just to determine how much or how well they have taken to heart some of the teachings that they have. Those are the things that I would look at in the MCLE, Your Honor.
Thank you, Dean, and I agree that those at the back have to snore less. Moving on now. One of the concerns is really being able to gauge the performance of the members of the judiciary. What would you propose would be a good way of gauging the performance of our judges and even our court personnel so that we can determine whether they would merit a promotion?
That's really good, Your Honors. First of all, the Filja, which is the education and training arm of the Supreme Court, should be empowered really to be able to ensure that only those who seek appointment in the judiciary should undergo their training program. But more importantly, Your Honors, the Filja undertakes every year an annual upgrading of judges and members of the judiciary all around in several regions. I think that what has to happen is that that would have to be upgraded in the sense that they would have to take courses. The judges, in order to seek promotion, and if this is respected by the JBC, must be able to go into a graduated training that will make them be qualified for greater. There must be merit in what they do. The other area, Your Honor, would be for the Filja to actually be able to divide the training that it has from centered at Padre Faura, to be able to divide them into regions, because each of the judicial regions in our country have different needs. We found that out. And therefore, if a Filja is able to regionalize and develop programs that allow the judges and their staff and to be able to get into trainings that would go into that would be a great work towards doing that, Your Honor.
For my last question, Dean, well, there has been this talk about outsiders, insiders. First of all, would you consider yourself an outsider? And second, do you think that the so-called insiders would have an edge over the outsiders as to being in the capability of the work that is required for the position of Chief Justice?
I don't consider myself exactly as an outsider, Your Honor. I have been involved in the Academic Council of PhilJA, and in many of the projects that we have undertaken with some of with the members of the Supreme Court. Therefore, I have come to know and worked with many of the incumbent justices of the Supreme Court. Some of them as members of the Academic Council before their promotion to the Supreme Court, and some of them as members of the faculty at that point. So many of them, they know me personally. I know them personally, so I'm a person who does not come outside and unknown to them. Therefore, if I do come in, Your Honor, it would be easy for me to work with them, as I hope it would be easy for them to work with me. But more importantly, Your Honor, on the issue of whether an outsider can do the correct work, we realize that the vacancy that has been created in the position of Chief Justice has been through an impeachment proceeding, as I said, that has pitted the three institutions in our society almost against one another. And perhaps at one time, the Supreme Court, I suppose, versus the two other branches of the government. And perhaps getting an outsider to work with the current members of the Chief Justice would be what the Supreme Court needs right now, especially an outsider who is not a stranger to them, and therefore especially an outsider who comes from the executive and can relate to them that matter, Your Honor. And in the end, perhaps that's what the Supreme Court needs right now, and perhaps that is what is needed in order to mend, so to speak, the relationship between the three branches of government, Your Honor, somebody who is from all of them. And therefore, an outsider like me would work with them and cooperate with them, not as to be superior, but the first among equals, and to be able to work well on how to allow the Supreme Court to be able to do its job better, especially in relations to other branches of government. The other thing, Your Honor, is that really when an outsider gets appointed into the Supreme Court, at that moment in time, he's really no longer an outsider. He becomes, at that point, truly one of the insider. And all of his being and the resolution that he has are all towards being able to work out very well with his colleagues in order to strengthen an institution that I'm sure that every one of those 15 justices love and care for, because it is the fulcrum of our democracy.
Thank you, Dean. With that, I wish you luck.
Thank you, Your Honor.
Thank you, Mr. Chairman.
Attorney Mejia, please.
Thank you, Mr. Chairman. Good afternoon, Dean Villanueva. For starters, I have two related questions. The first is, at what point in your life, or more specifically in your professional life as a lawyer, did you entertain the thought of becoming a Supreme Court Justice? And the other question is, just how passionate are you in becoming one?
All right. I think that what attracted me to being to the position of a justice of the Supreme Court was when I started to work as a member of the Academic Council of the Philippine Judicial Academy. There we began to interact with the justices of the Supreme Court, also justices of the Court of Appeals, and you could see that within the Supreme Court and the Court of Appeals, some of the best legal minds, some of the best Filipino patriots that you can see. And working with other judges, trial judges, you also see some of the great heroes that are there, where they dispense justice, in spite of the fact that they work under conditions of privations. And yet, every day, in spite of the temptation, they try to dispense justice. These are people who, I would say, carry the face of the Republic towards being able to, they could have had options. Some of them have graduated from some of the best law schools, but they continue to be there because they believe in justice. That was the time when I said, it's really not a bad job. It's a job where after doing it well, you would say at the end of your life, I have made it, life has been meaningful. That's when I began to see the attraction for the judiciary, Your Honor.
Thank you. What is your vision of the Supreme Court? Should you become the Chief Justice?
Well, my vision of the Supreme Court is what I read earlier, that it becomes more than just a trier of facts, more than just a constitutional court, of which it should be. That's the most important thing. It fulfills that job. But it becomes truly one of the three main pillars of our republic in being able to usher in the good life for our people. That it becomes a critical and yet interdependent member of the triumvirate. In other words, it is not at the forefront of trying to promote economic development here, because that's probably the main job of the executive and the judiciary and the legislative, but it does guard the precepts that are there in the Constitution to ensure that as we struggle towards development in this country, changing the lives of our people, that the programs do follow the economic policies laid out in the Constitution. I believe this is important because we have many complex problems here brought about by lack of good education, by poverty. And we know that many of these would be unlocked if we begin to have economic development in this country. How can people ask for democracy if they are starving? These are the finer things that only the middle class and perhaps even the well-off can take advantage of. So being able to move many of the members of our society towards a better economic family existence would usher in solve many of the problems that we have in this country. And the Supreme Court could be at the cutting edge of that, Your Honor.
What would be the immediate problems that you expect to encounter once you assume office, and how will you deal with them?
The immediate problems I see is that first there's an issue of whether what interest I represent. Do I coming from outside, as they say? Do I represent the interests truly of the Supreme Court? And the next item is that how far will I go? I think that sometimes I think that my reputation has preceded me in that I mean what I say and I do what I say. That's also the same principle that we have adopted in the Governance Commission. We will not ask of the boards of directors of GOCCs what the Commission itself cannot do. And therefore, if we ask of them good governance, we must be 1,000 times better than just being good governance. And therefore, I think it's the sweeping changes that may be demanded of, the accountability that may be demanded of, that are the changes. But I think that many members of the Supreme Court who know me personally would be able to know that as I've worked with them, we only have everybody's good intention to resolve, all consistent with trying to build a better republic. I think those are the change that probably they expect to come.
There is, and I am now starting to read from the suggested questions from the public, there is jurisprudence which in essence states that the mistake of the lawyer binds the client. Is this not an unfair ruling?
It probably is, Your Honor, but in the end, that's how important the role of every lawyer is in society. They are the ones who have received the training. They are the ones who have received, in fact, a license from the Supreme Court to represent the client's interests. And therefore, the clients must be able to choose their lawyers very carefully, because in the end, the mistakes of the lawyer become their own. And the problem with that, Your Honor, is that some lawyers will make a mistake, some of them intentionally, some of them maliciously, and it just ruins the entire profession. It ruins the reputation of all the other lawyers who daily try to find their way towards achieving justice for the members of our society. And that particular point, therefore, emphasizes the strong role that lawyers play in our society. And we see that, Your Honor. You may not, when one becomes a lawyer in the family, he need not be the eldest, and the whole clan turns to him for advice, even the kuya. And the same thing in our society. The lawyer tends to be derided, but people in need always feel that the best defenders of their cause would be a lawyer because he has the training. Therefore, that the upliftment of the profession is such an important aspect of development, Your Honor.
Thank you. I will now read the last two questions that I intend to ask as inputted. The Supreme Court Justice is expected to handle all sorts of cases. Is not your specialized expertise in commercial law mean that you have limited knowledge of the law?
No, Your Honor. In the end, I think it is important for professionals to choose an area that will animate them, that will impassion them, that will enchant them so that they become the best and the brightest. But in doing that, as they say, the law is always interrelated. In fact, many of the principles in commercial law have to do with contract law. They have to do with constitutional law. And in my search of being an expert in commercial law and corporate law, I have always had to deal with the policies consideration behind them, market forces, and more importantly, the writings do indicate that I have to consider the constitutional basis by which certain commercial law principles are there. So it has not been, and I've also been engaged in litigation all my career. In the latter part, it has been corporate litigation. So it is not true that by being one of the by trying to become one of the leading minds in commercial law, one is completely oblivious of the other areas of discipline. It is not so. Because if it were so, then you really are not a great mind in that field, so to speak, Your Honor.
For my final phone-in or tweeted-in question, what is your position on fraternities? What advice will you give law students with regards law school fraternities?
All right. One of the problems I've had when I became dean of the Ateneo Law School was, in fact, fraternities. I belonged to one, and I knew that one of the greatest challenges and the measure of how I've been a good dean is whether I could live beyond fraternities and association. So one of the things that we made sure was that to get out the message that if you're a fraternity abroad, then it does not give you an advantage. In fact, it gives you more disadvantage because you swear that excellence is your aim. Then you have to prove that you have to be better than the next one. But more importantly, we made sure that the rules on discipline were enforced fairly to make sure that justice is meted out very quickly and to make sure that they are always met by people who are undoubted caliber. So, and the most important thing, Your Honor, is that we realize that fraternities in almost all law institutions are there to stay, whether it be the UP College of Law or the university law schools, because it seems to be a natural gravitation of men and sororities for women to belong, to want to belong. And therefore, instead of trying to outlaw them, well, the best thing to do is live with them, but live with them in a way that you give the students fair competition. So, with the now dean of the law school, Cedric Candelario, who was then the associate dean for academic affairs, we made sure that life in the law school would have many options other than just joining a fraternity. That life in the law school, the survival and the ability to thrive is just beyond fraternity, being made a fraternity. In fact, we made sure that with the items that made you great lawyers, like mooting activities, like being part of the church group, by many other activities, the law journal, we made sure that they would see that in fact by being a fraternity you miss out on the good things that would make you a wonderful person, a better person, and a better lawyer like that. The ability to be able to give them better choices. If there's a great idea beyond fraternity, then the solution was to give them a better idea and a better ideal. This is what we proceeded to give, so that it became a mark of distinction, even as when they went to practice, to have been part of a mooting competition, to have represented the Ateneo and the Philippines in international mooting courts, and to have won world championship. To have written journal articles, to have been part of the Ateneo Law Journal. Those are the things that are really badges of what makes a great lawyer. That's how they should be handled, we thought, Your Honor.
Thank you very much and good luck, Dean Villanueva. Thank you, Mr. Chair.
Justice Lagman, please.
Okay, thank you very much, Mr. Chair. Dean Villanueva,
Yeah.
good afternoon. Your record shows, and as you have stated earlier, you are the present chairman of the Commercial Law Department at the PhilJA.
I was, Your Honor, until I
Are you-
accepted the chairmanship of the Governance Commission. I thought it was not fair that devoting all my full time to the GCG, I should retain the chairmanship of the Commercial Law Department of PhilJA.
So you
Your Honor.
left PhilJA already?
Yes, Your Honor.
When did you?
Last year, Your Honor, shortly before I assumed the chairmanship of the Governance Commission, Your Honor.
I see. Anyway, you have been involved in the PhilJA. Now, what is your vision for the PhilJA if you will become the next Chief Justice of the Supreme Court?
I've been involved. I was fortunate enough to be with PhilJA. At the time, it rose to heights under Justice Amorfino Melencio Herrera, and then was with it when Justice Ascuna took over. And PhilJA is very much respected by many international agencies that are offering reforms, and they always go to PhilJA to do that. And it has been revitalized to an extent that it is truly one of the great pillars right now of the Supreme Court. Could it be greater? Of course it would, Your Honor. We were, before I left the Commercial Law Department, Your Honor, we were tinkering with being able to regionalize PhilJA. In other words, we were thinking of being able to put up satellite offices and a satellite organization in each of the judicial regions in our country, and for them to be responsive to the areas that were there. We were seeing that some of the programs that were relevant to some people, some of the judges in one region were irrelevant to the others, and therefore so much funding of the Supreme Court was going into all of this training program. We wanted to make sure, therefore, that PhilJA began to be important, responsive in each of the region by doing regional one, and to be able to train within each of the regions not only an organization but some of the core professors who would be known to who've decided to devote their careers in the province, Your Honor. That's one area, Your Honor.
Okay, thank you very much, Dean. Now, let's go to another point, Dean. It is given that the two political branches of government, namely the executive and the legislative, have the primary responsibility of promoting the economic well-being of our country. A former Chief Justice once said that the judiciary has a similar duty to nurture prosperity and alleviate poverty in our country. Do you agree, Dean?
I agree, Your Honor. Very much so.
Okay. Now, if you will be the next Chief Justice, how can the courts nurture prosperity and alleviate poverty in our country?
Our Supreme Court is in a unique position compared to the Federal Supreme Court in the sense that our Constitution, in fact, has economic and commercial precepts and policies.
Yes.
Therefore, the Supreme Court has often said that it is not their choice when it comes to economic policy. It's not their choice that they should have a say in it. It's their bounden duty to ensure that the economic policies within the Supreme Court are followed. I wrote on this, Your Honor, on the philosophical underpinning of the commercial law provisions of the Constitution, and I said, you notice, compared to American Constitution, our Constitution has needed to have economic policies, mainly because we're a country that's trying to find its way. We are not a we're merely a developing country, and therefore it was imperative for our writers to put in what they felt were the aspirations of a nation. But I did say there that the economic terms of the Constitution are not addressed solely and alone and primarily to the Supreme Court. They're actually addressed to the policy determining bodies. And therefore, the primary role of moving this country forward, of trying to alleviate poverty, of trying to make life better for everyone, is really the primary role of the executive and the legislative. And the role of the Supreme Court is not to preempt them into this. In fact, it should look at it should consider that a determination by the executive or legislative branch of an economic program is the way to do it. And unless it really is contrary to the constitutional precepts, it should live by this. And unless there's abuse of discretion, the Supreme Court should take this. And then, in areas where the members of our society object to the economic policies of our two policy determining bodies, then it is the duty of the Supreme Court in deciding such issues brought before it, not justifiable controversy, to actually find and explain if it is correct the policies, the directions, and the programs that have been taken up by the both policy determining and executing branches of our government. To me, that's the role of the Supreme Court, to work very closely, at arm's length, but very close, to work very closely at being able to allow our policy determining and policy executing branches to be able to carry out the work that they have. We must presume that our legislator, it is not just the justices of the Supreme Court who have our country's progress at heart, but primarily also the executive and the legislative, Your Honor.
Okay. In relation to this, Dean, our new constitution imposes upon the courts not only the power but the duty to strike down all acts committed by any branch or instrumentality of the government with grave abuse of discretion.
Yes.
What do you think would be the effect, or what do you think is the effect of this provision on the courts?
Well, it means that on the courts, on the Supreme Court primarily, and the courts in general,
Yes.
it means that they have been granted expressly by this new provision in the 1987 Constitution, with abounding duty to be vigilant, so to speak, over when it comes to the exercise of powers by both the executive and legislative branches. Mm-hmm. But only when there's a grave abuse of discretion should the courts come in. In other words, they are not supposed to second guess or preempt or to supplant the policy, the determinations of those bodies. Only when there's a clear showing that indeed they have overstepped, has been abuse of discretion, do the courts come in. And that's a duty that's a very powerful. That's a very powerful duty on the part of the courts, which they must use sparingly, unless there's a clear showing of abuse of discretion, Your Honor.
Okay, Dean, let's go to another point. Corruption is one of the most serious problems in the judiciary. If you will be the next Chief Justice, how are you going to address this problem?
I think the more, first of all, Your Honor, when there's so much discretion, so much vagueness in the rules of procedure in the law, that actually, and there's no transparency, that actually engenders corruption. Therefore, the rules have to be streamlined so that there's less discretion and there's more transparency towards that. I think that's pretty important, Your Honor. Mm-hmm. The other one would be non-tolerance, Your Honor. I think that when a body comes together, there's a tendency out of self-preservation to try to cross over the bad eggs because it affects the institution as a whole. I think that the public realizes that corruption in the judiciary is so bad that there has to be a clear call for it. So I think that the Supreme Court, through its justices, should work very closely with government agencies in order to monitor very carefully through the Anti-Money Laundering Council, with the NBI, with the Ombudsman, very carefully do a lifestyle checks on all of the judges and justices down the line, and to show that indeed there is intolerance, there should be zero tolerance. In the end, Your Honor, we will not be able to stamp out corruption entirely, but we would be able to control it, and we would be able to show that if you get caught, you will be prosecuted. I think that's the only way to go about it, Your Honor.
Okay. This is the last question coming from me because I still have question from the Twitter. Okay, Dean, can you tell us your top 3 priorities upon assumption of office as the next Chief Justice of the Supreme Court?
Well, first of all, Your Honor, my top priority would be basically to unite the Supreme Court. Not only all the 15 justices together, but also all those who work with the Supreme Court, many of whom have been my former students, and to be able to, what we call, do a strategy roadmap. It is my intention to confer with the 15 members of the 14 members of the judiciary because they have been at it for quite a while. They realize the problems that are there. They know they probably have some of the solutions that are there. I have my own assessment, my own inputs. Together we will try to and do what we call a strategic roadmap for the Supreme Court as a whole and for the judiciary as a whole, and then work with the other appellate courts down the line. And perhaps there is a need to be able to solve basically the problem that is at the heart of many of the 15 justices. I've been told that they just carry too much in their dockets, almost inhumanly loaded, that the other thing of moving forward is difficult. And therefore, we will work with them in order to ensure that as much as possible, the Supreme Court becomes a constitutional court, that most of the decisions that it goes are matters of constitutional issues, and that the other matters which are not precedent setting, there's a way to be able to solve that, to ensure that as a matter of practice it is limited to the level of the Court of Appeals. And having deloaded them in that case and only concentrating on important cases, Your Honor, perhaps it is only fitting that each of the justices become responsible for a judicial region. But for them, they will show the face of the Supreme Court in each of the judicial region and do a good job at making sure that the dispensation of justice goes well, that access of the poor to justice goes well, that declogging goes well. The other would be, of course, Your Honor, trying to see how the various programs that are in place towards declogging the workload of our judges and justices and judges is done. So much has to be done. And I think that this will be resolved by the third item of being able to recruit the best and the brightest. There are many empty salas right now, and I think that once you're able to attract into the judiciary some of the best and the brightest, competent, they themselves will know how to and be able to put upstream how to handle the court dockets and work with items like ADR and JDR, Your Honor. Those are the 3 items that I would look into, Your Honor.
Thank you very much, Dean. Now, I will read to you some of the questions from the Twitter. Okay. Now, I will read it. Considering that the checking of the bar exams is too subjective and time-pressured due to checking 6,000 booklets in a few months, will you consider to amend the limit from 5 attempts to a new limit of 10 bar attempts? Additionally, do you agree to reduce the number of bar subjects to 3 or 4, just like in the U.S.? This is from a certain Tads Bentulan.
All right. No, Your Honor, on the reducing of the bar subjects, I think that this has gone through so much genesis and study. I would maintain them. I think these are the 8 areas where it is important. In fact, I would go with trying to ensure that judicial legal ethics is spread throughout, as is the plan, I think, of the current chairman of the bar exam, to make sure that an integral part of each of the substantive bar subjects would carry application of ethical standards. No, Your Honor, I think that the Supreme Court, once it makes a decision, we presume that the Supreme Court has made a well-considered decision. And when it issued the memorandum circular saying that from here on, it's 5 attempts, you're out, I think the Supreme Court should stick with that, Your Honor, because it doesn't do good to the integrity and the reputation that the Supreme Court changes its mind on that, Your Honor. I think that if you've had 5 bar attempts and you haven't quite passed it, you'd be doing yourself and society better if you go into other things where you will shine. I think that's the important career point there, Your Honor.
Thank you, Dean. This is another question. Would you agree to my proposal that this is also from Tads Bentulan. Would you agree to my proposal that the justices of the Supreme Court should have the same allowances and salaries as that of the central bank governor, who has high salary and allowances to prevent corruption and to elevate the economic dignity of the judiciary?
I'm not aware of the salary standard of the Bangko Sentral governor. It probably is very high. But I would say this, Your Honor, I think that judges and justices should be well paid. I think that if we want quality justice in this country, our republic should be willing to give them quality pay. I think that we should live by the words, you put your money where your mouth is. We want our judges and justices to dispense justice in the best way possible. Therefore, give them a compensation that will allow them to concentrate on doing just that, and at the same time be able to provide with dignity for their families, to be able to send their children to good school. I think that's important. I think it's a shame that when you look at our national budget, I think less than 1% of the national budget is given to the Supreme Court or to the judiciary. If the Supreme Court is truly one of the 3 important pillars of our government, then it deserves a budget higher than 1 or 2%, Your Honor. And therefore, they should all be spent towards making sure that from the Chief Justice down to the sheriff and the process server, they are paid well. And they're well qualified, they're hired well, and they're paid well. And they spend their lives doing exactly just that, being part of the judiciary. No matter what they are, the sheriff, being interpreters, stenographers, and know at the end of the day that it has been a good life, that it has been a dignified life for them and their family, and then it was a life of service to this country.
On that note, I have no more question for Dean Villanueva. Thank you very much, Dean.
Thank you, Your
Good
Honor.
luck.
Justice Hermosissima, sir.
Good afternoon, Dean.
Good afternoon, Your Honor.
The definition of outsider was made by our predecessors. Their meaning is that outsider is an applicant who is not yet a judge. That is what they mean. I have no objection to this, to outsiders being appointed to positions in the judiciary. As a matter of fact, the first appointments of President Cory Aquino to the Supreme Court were all outsiders, except for then Judge Amor Herrera. All the others, like Chief Justice Narvasa, Chief Justice Marcelo Fernand, Yap, and many others. They were all outsiders under that definition. So I have no objection to outsiders being appointed to judicial positions. When Eisenhower ran for President of the United States, he went to Governor Earl Warren and said, and told Earl Warren, you help me in my campaign for presidency, and I'll appoint you to the first vacancy in the Supreme Court. Earl Warren was governor of California. It happened that the vacancy was that of Chief Justice of the Supreme Court of the United States. So Warren asked, I said, will you you appoint me now as Chief Justice? He said, no, I mean Associate Justice only, not Chief Justice. And Warren said, if you have any word of honor at all, you will appoint me, because you said the first vacancy in the Supreme Court. And so Eisenhower was forced to appoint Earl Warren. It turned out that the Earl Warren Court enunciated so many doctrines, among which was the Miranda Doctrine. That is a classic in human rights. So that's that. Now, what is important really is our perspectives in the matter of applying for positions in the judiciary. Well, what is your judicial philosophy, Judge, when you become a Chief Justice of the Supreme Court?
My judicial philosophy, Your Honor?
Yes.
Well, when it comes to fundamental rights and human rights of people, then the Supreme Court must take, as it has taken, an activist role. It must ensure that there is no derogation at all to the rights guaranteed to our people under the Bill of Rights. When it comes to other rights, economic rights and economic policies, Your Honor, I think that the Supreme Court must take a passive role, realizing that those constitutional provisions are addressed first and primarily to both the executive and legislative department. And that, as a matter of practice, the Supreme Court should not supplant its own economic theory to those that have been pursued by way of policy determining of the legislature or those of the execution process thereof by the executive, Your Honor. I think that the Supreme Court, therefore, should primarily take the role of being a constitutional court. That, like the U.S. Federal Supreme Court, it should not overburden itself with so many cases, overburden its justices with so many cases, and be able to concentrate on what we call the important constitutional precedent-setting decisions, so that when the Supreme Court does speak, it always speaks with what I call like a thunder, that it is setting the law or affirming a policy, and that in all other cases, it should, as a matter of policy, consider the determination of decisions of cases coming from based on the decisions of the Court of Appeals as basically settled, and unless there's clear abuse of discretion, that it should not allow them to go into the marriage, Your Honor. That's my philosophy, Your Honor.
Can you not shorten it somehow?
Oh, yeah. A Supreme... Yes, Your Honor.
Well, it's so hard to digest that. Just like, for example, the ideal of the integrated bar of the Philippines, like no master but law, no guide but conscience, no aim but justice.
Yes, Your Honor. The Supreme Court that serves primarily the needs of justice in this country, in all its aspects, Your Honor.
Well, there's another matter. You were talking about the bar. I don't want to demystify bar top-notchers, but then there are sectors there are several sectors which propose to abolish the bar. Their idea is to give examinations to the first year students after finishing the first year, and then examinations for the second year, examinations for the third year, and the examinations for the fourth year.
Yeah, sure.
In that way, well, examinations may be given by the Supreme Court or a committee in charge of that, or by the CHED, or by the Board of Legal Education.
Yeah, sure.
In that way, you already eliminate those who don't deserve to be lawyers from the start. But can you imagine when you of the results of the bar says that only 15%, 20% pass, and so what happens to the 80%? They're jobless. So that's the idea. So even from the start, just like what do you call that in college, ICQ. Even from the start, you already eliminate those who do not deserve to be lawyers. What do you say to that idea?
Yes, Your Honor, that would be good, but that means that you must play a very high, a very strong weight on the shoulder of the Legal Education Board, because it's possible, Your Honor, that it is possible that certain law schools are so differently situated that in order to attract students, at least to make their law school at least survive, that they begin to go down on the criteria of what we call academic excellence. I think that's the allure of the bar examinations, Your Honor. It is the hardest government exam being granted, and it usually epitomizes the work, the great intelligence and the hard work of some of the brightest and most diligent men and women of this country. In other words, it is a mark of excellence. And therefore, if we can translate that, Your Honor, into the law schools, by all means. But that means that being able to accredit the law schools and being able to monitor them and ensure that only the best and the brightest, those who are qualified to enter the legal profession, are allowed to operate. And there's a system of checking this, Your Honor. Yes, that would work, Your Honor. But that means that we would have to close down almost half of the law schools in this country, because some of them are just graduating as bar results will show, more than half of them are graduating.
There are only a few who try to make money out of law schools. But really, there is no law schools do not make money. They want only the name.
That's right, Your Honor.
But well, one idea would also be to limit the number of law schools.
That's true, Your Honor. I think that's the best.
In Hong Kong, there are very few lawyers, only about 2 or 3. The reason is that there is no law school in Hong Kong.
Yes.
If you want to be a lawyer, you go to London to study law. Only then will you be qualified to.
The same thing in Singapore, Your Honor. There are only 2 law schools, and you cannot open one unless the government says you can open one. That's how important the legal profession is in those societies, so that they make sure that not everybody can enter it unless he's so well qualified, and not everybody can survive it unless he is of that stuff. Because the greatest sin that you can impose into society is to unleash ignorant lawyers, Your Honor. They do all sorts of evils, consciously or unconsciously, Your Honor.
And then there should be a delineation between a trial lawyer and the solicitor, like in England. Only the solicitor will only delay the proceedings if you allow him to go to trial.
I see.
Whereas the barrister will be the one going to trial. Well, the solicitor solicits cases and prepares the evidence for the barrister. The barrister appears in court. Why don't we have that? On that note, thank you very much.
Thank you, Your Honor.
Secretary Mosngi.
Thank you, Mr. Chairman. I just want to disclose that he was a former professor of mine at the Ateneo Law School. I believe he gave me a grade of 89. I have no further clarifications.
Because Secretary Mosngi and Attorney Cayusa disclose their relationship with Dean. I will have to disclose mine also. Well, Dean and I were together in the study tour in Canada in 2005. He was the one who recruited me as part of the faculty of Ateneo.
And they miss you, Your Honor.
And how's that?
They miss you there, Your Honor.
Oh, yeah. And introduced me to the bar review program of the Ateneo. Then we were also together many times in the academic council in the Philippine Judicial Academy, and also in the preparation of the bench books for judges, I think. Yeah. And because he said that one of his first priorities is to increase the salary of justices, I was thinking I will still ask him questions because I know his qualifications. No? But there are some questions in the Twitter, Dean. May nagtatanong na Muslim eh. His question is this: may I be pleased that questions be propounded to the CJ aspirants concerning their thoughts or perspectives for the development of Sharia, both as profession and judicial system in the Philippines per PD 1083. Can you answer this question?
Yes, Your Honor. In the Philippine Judicial Academy, there is a particular department headed by retired justices, Muslim justices, who actually take care of the Sharia program. In fact, and they're part of the academic council. And in fact, much of the budget of PhilJA when it comes to training is training on Sharia courts, as well as a training on understanding within the areas where Muslim population are the highest of Sharia law, especially a comparison between civil law, personal law, and the Muslim code, and therefore, yes, there is such an important consideration given both in the Supreme Court through the PhilJA of being able to make sure that Sharia develops and the Sharia court system develops. And perhaps that's one of the things because the common complaint is that some of these are unfilled up in the South, Your Honor. Perhaps that's one of the other things that PhilJA should work with the executive in order to be able to fill this up with qualified people, Your Honor.
Just one or two questions. No? You're a member of the Committee on Commercial Law?
I used to be, Your Honor.
I used to be, and I think even in the Rehabilitation Committee.
In the Subcommittee for Commercial Courts, Your Honor.
Are there provisions in the rules on commercial courts that were introduced during your time as member of that committee purposely to expedite the termination of commercial cases?
Yes, Your Honor.
Will you please enlighten us, Dean?
Yes. the interim rules, when they were first promulgated by what they call the SC Corporate Committee, tried to put in place what we call experimental but not revolutionary matters. For example, making sure that there are certain, not only that there are prohibited pleadings, making sure that there is no need for oral arguments, that evidence can be presented by an affidavit, making sure that they're time bound, making sure that judges, when they do not render decisions within the time mandated by law, that the petition is deemed to have been denied, and judges are made subject to administrative penalties. When those came to us, we said, we did write about this and how a great experiment this is, that because it's commercial law issues, usually it's just about business, it's about monetary inclusion, that it is possible to be quick about it. When I became a member of the subcommittee, among the other things that we did was to be able to revise the interim rules to become the regular rules by incorporating therein not only the rehabilitation aspect, but including insolvency provisions, because the insolvency law is a law that has become in disuse. And therefore, what we did was to look at the pending bills, the bill that has almost matured in Congress. It was called then the Corporate Rehabilitation and Insolvency Act, CREA. And we inputted them into the amended interim rules, and the Supreme Court did, in fact, pass them as we amended them to make sure that not only corporate rehabilitation are decided in the most expeditious manner, but including corporate insolvency and as well as individual insolvency. It turned out, Your Honor, that when Congress, after 2 years or 3 years, did pass that law, it became FREA, the Financial Recovery and Insolvency Act. The Supreme Court was mandated to actually issue rules, promulgate rules of procedure that were in line with that. And the truth is, they were already there. In other words, the Supreme Court, to its rules, was much ahead of the FREA. So even if the Supreme Court has not particularly amended those rules or issued rules of procedure pursuant to the FREA, the existing rules of procedure have now anticipated it, and judges still have, therefore, a set of rules by which to follow in this case, Your Honor.
Last question. Did I get you right that they miss me in Ateneo?
Yeah, very much so, Your Honor.
So my next question is, if you become the Chief Justice, will you allow me to teach?
Yeah, we will all teach on Saturdays, Your Honor.
On that note, I'm through, Dean.
Thank you, Your Honor.
Tomorrow is our last day. We will have 2 in the morning and 2 in the afternoon. So we will start at 9 o'clock. So thank you. Session for today is adjourned. Tatanungin ko na sana kayo. Sinabi.